them either.
Sorry, this is very simple. Just one. I have a session. Just one day. There are 189 deals with what is called vertical star exercises.
Binding on all other courts. That's right. And not on ourselves. That's why I said, of course, there are weighty precedents. That doesn't mean we are shackled by them either. That's why I read out the passage from Justice Philip Green's book. My respectful submission is.
Then tomorrow, a two-member bench will pick up whatever judgment or judgments come out of this full court and say, we are not bound by that.
No, this is not what I said. This is exactly not what I said. So I never said a two-member bench is not by a larger bench. So that is absolutely not what I said. It will be a larger bench. The larger bench is not shackled by, or the full court is certainly not shackled by precedent.
My Lord, if I may now proceed. My respectful submission is that the Constitution never acknowledged Chief Justice as master of roster. Therefore, at any rate,
ये term पहली दुनिया में कहाँ इजाद हुआ ये?
my Lord, is there
हिंदुस्तान से हम लोग अंग्रेजी सीखते हैं ना, तो वहाँ ये इस्तेमाल होता है या नहीं होता है?
Sir, Lord,
मुझे नहीं पता ना, मैं आपसे वाकई सवाल पूछ रहा हूँ, जेन्युइन सवाल है। आपको पता है, बताइए, नहीं पता है, पहले पता है।
I'm not aware of when it was used for the first time. I'm not aware when it was used for the first time as a term of art. I mean,
नहीं, term of art नहीं, कहीं इस्तेमाल हुआ। कानून में हिंदुस्तान के भी हम कहते हैं ना, हम इंस्पिरेशन वहाँ से अगर हम ले रहे हैं, तो ये इसका जेनेसिस बताइए।
एक चीज का
जैसे जमहूरियत का जेनेसिस कुछ लोग कहते हैं मैग्ना कार्टा में है, तो चलें ये इस टर्म का जेनेसिस कहाँ है?
मैं एक चीज जरूर बताना चाह रहा हूँ यहाँ पे कि जब after the British assumed control of India after 1857, तो फिर यहाँ पे हाई कोर्ट्स बनानी शुरू की उन्होंने 1816 the first year जब 3 हाई कोर्ट्स बन गए and then I looked up the data actually. Madras, Bombay, Calcutta 1862, Allahabad in 1866 and then Chief Court of Mysore in 1884. And the Federal Court India बनी वो ज़ाहिर Government of India Act के बाद बन गई थी तो 1937 में बनी. Out of these 6 courts, 1862 जी there were others, मैं तो 6 करेगा.
many others.
There were several others. 1862 till 1947, out of these 6 courts, there were a total of 62 Chief Justices. And my Lord would be, I was quite amused, well not amused, one would actually understand why. In 1862 till 1947, the British Chief Justices representing the Crown in any rate, by race as well, and exercised by them, purpose being, in my respectful submission, to actually ensure that the courts are regulated.
आप इस सवाल का जवाब नहीं दे रहे हैं।
वो कौन सा सवाल है?
मास्टर के इधर शुरू हुआ पहले।
ये मैं I will have to go back and Google it. I can't find it.
हिंदुस्तान में इस्तेमाल होता ही है।
I don't imagine.
अमेरिका में इस्तेमाल होता है, कहाँ इस्तेमाल होता है?
नहीं होता।
हमारी इजाद है क्या है, जरा बताएं तो ना।
ये
brought it from our school days. You see, with the master, the school master.
But
I thought the roles तो मैं समझ हिंदुस्तान में आते हैं, मगर मास्टर का रोस्टर मुझे नहीं पता। मतलब इतने वकीलों ने बात की, मगर किसी ने इस बात से जरा वजाहत नहीं की, मुझे नहीं पता इसका।
ये तो आपका फुल कोर्ट बैठी है, I'm sure you can find out. I'll look it up. I'm not going to break if I can. But what my submission was that if at all it was a convention, this convention has to be disregarded because this convention is rooted in the colonial past. It must get it.
फिर अगर दूसरी बात आ जाती है, अगर हम कॉलोनियल पास को अपने सराह रहे हैं और अपने इस्लामिक पास को नजरअंदाज करते हैं, इस्लामिक पास में कोई मास्टर ऑफ द रोस्टर कॉन्सेप्ट रहा है? जब फिर वो वाला सवाल उठेगा, और अगर नहीं है तो फिर हमें हमारी जो लाइट्स हैं वो तो हमारी लाइट्स कहीं और है ना, 1400 साल से पहले वहाँ हम देखते हैं। हम अपने कॉलोनियल मास्टर्स से तो ना सीखे ना, कि अदरवाइज फिर आज़ादी हासिल करने की भी जरूरत नहीं थी। रहते चलता था निज़ाम, वो सब तो चल ही रहा था, लोग खा रहे थे, पी रहे थे, रहे थे तो फिर आज़ादी की भी क्या जरूरत होती। तो ज़रा ये आप लोग बिल्कुल छोड़ देते हैं। कोई इस्लाम पे बहुत हल्की बातें हुई, ज़्यादा नहीं हुई, इसके बावजूद के आइन में कई जगह तस्करा है उसका। शुरू ही होता है सीक्रेट ट्रस्ट, और सीक्रेट ट्रस्ट में तो मेरे ख्याल में सीक्रेट करने अमानत की बात, तो मास्टर का कॉन्सेप्ट क्या कोई डिस्ट्रक्टिव नहीं है? मास्टर तो एक ही है, ऊपर वाला। ऐसे बावजूद क्या नहीं आप बताएं।
My Lord, I had submitted on the first hearing as well that what the Parliament surely hasn't done is it has not arrogated this power of constituting the benches either to itself or nor has it conferred it upon any element or individual outside of the judicial branch.
Who is now under this act, assuming that it is constitutional, who is now the master of the roster?
There are masters, co-masters of
The
the
masters of the roster. Or let's use the collectivity as a single
co-masters.
But the question still remains: who is the master of the roster? The committee. They do exactly what the Chief Justice does.
So let me just rephrase it.
Whether you like this phrase master of the roster or not, I am using it to express in shorthand the concept of what it is that Section 2 of this Act uses to do.
My Lord, what
In that sense, who is the master of the roster? Three judges.
you've done away with master of roster.
Three judges now.
No, it's a collegium. It's a collegium.
अब ये तो जवाब कि कोई भी
जज्बाती होने की जरूरत नहीं हाँ जज्बाती ना हो कमेटी बट द कमेटी मेंबर कमेटी जज्बाती नहीं। देखिए ये भी एक सोचने की बात है कि 1947 के बाद से हमारे पास 56 का आइन आया, 62 का आइन आया, 73 का आइन आया, इंटरिम में कॉन्स्टिट्यूशन आई। Consciously, deliberately, the people of Pakistan expressed a will to follow models that were existing that go back to the Government of India Act, colonial, that go back, if you go further back in history, to the British North America Act of 1867, Canadian Constitution, colonial. So, 4 times or 3 times the people of Pakistan have made it exclude the 1962 Constitution because that was a
Not colonial.
no, because that said, now therefore I, Field Marshal Muhammad Ayub Khan, give to the people of Pakistan this Constitution. 56 Constitution and 73 Constitution don't say that. They said, we the people give this Constitution to ourselves. That's the reason. So let's not go into what is colonial and what is not colonial and remain focused over here. A collegium, committee, whatever you want to call it, of 3 judges now controls all the affairs. Okay? You say that is good, that is progress. I put it to you, well, why not the full court? Put it in the hands of the full court. Why should, for example, if one judge, if I don't agree with that, by the way, what I'm about to say, but if one view is that 15 minus 1 is 14. 14 judges are in thrall of the Chief Justice. Now 15 minus 3, 12. 12 judges are in thrall of 3 judges. If the committee is 5 judges, 10 judges are in thrall of. अरे भाई फिर कर देना फुल कोर्ट। जो चीज हमारे रूल मेकिंग पावर की प्रैक्टिस और कन्वेंशन है फुल कोर्ट ही करेगी। ठीक है, अगर पहलों ने नहीं किया चले आप कर दें। अगर किसी को शिकायत है कि पिछलों ने नहीं किया चले आप कर दें। किसने रोका? आपके कानून ने रोका है। आपके कानून ने मुसल्लत किया है। With all due respect to whoever because judges come and judges go, whoever is for the time being member of that collegium or committee, आप देखिए आप जो बातें कर रहे हैं ना, आप इसकी विद ऑल ड्यू रिस्पेक्ट, और ये मेरी आपसे मुअद्दबाना गुजारिश भी है और एक क्वेश्चन भी है, आप फिर उसी को अंडरमाइन कर देते हैं। कहेंगे कि जी 1 मैन, मैं अगर अगला लफ्ज़ इस्तेमाल करूंगा तो 3 मैन और पर्सन, आई एम सॉरी टू जजेस सिटिंग ओवर हियर, और 5 पर तो खत्म कर देना भाई। हम जब कहते हैं हमारा फुल कोर्ट करती है ये काम, प्रैक्टिस और प्रोसीजर सुप्रीम कोर्ट ने कहता है, आपने हमें चक्कर दिया और आप कहते हैं कि दिस इज प्रोग्रेस।
मैं तो पता नहीं था कि आप समझ नहीं आ रहा है क्या मुझे नहीं साहब ने कहा तो नहीं हो सकती है
आप ये प्रोग्रेस है या नहीं है, हमारे सामने तो सिर्फ आईनी सवाल है जो जा साहब ने भी पूछा हुआ है कि बस मेरे हिसाब से तो ये सवाल बनता है कि ये कानून आईनी है नहीं, अच्छा है बुरा है, उसको भी तबसरे हो सकते हैं, बहुत सारी राय दी गई है, कोई समझते नहीं अच्छा है, कोई समझता अच्छा है, तो चलिए ठीक है, उससे फर्क भी नहीं पड़ेगा। ये कानून बरकरार नहीं रह सकता है अगर ये आईनी नहीं, खत्म। और चाहे कानून जो भी अच्छा हो बुरा हो फिर भी बरकरार रहेगा अगर आईनी है, तो बात तो वहीं आगे ठहरती है। मगर अगर वजूहात पे जब जाते हैं ना कि क्यों किया, तो क्यों किया में तो बहुत सारी वजूहात हैं और वो जहाँ तक बताई गई हैं और मेरी ज़ाती राय में एक अच्छी वजूहात दी गई हैं। अब उनकी नीयत क्या थी, नीयत तो कोई नहीं देखता है ना, वो तो ऊपर वाले नीयतों में आप नहीं जाते हो ना। वो लोगों ने कलमे पढ़े जब उनका गर्दन तलवार के नीचे थी, तो मगर फिर भी उन्हें पढ़ लिया तो बात खत्म हो गई थी। तो हम उधर नियत ही क्यों जा रहे हैं, हम सीधा आईनी बात है, छोटी सी बात है, इसका इतना हमने लंबा इसको खींच रहे हैं, अच्छा है बुरा है, ऐसा किया वैसा किया है। तो और दूसरी बात है कि आप एक दूसरे को लड़वाएं तो नहीं, आप एक इंस्टीट्यूशन को तो दूसरे से, हम उस इंस्टीट्यूशन की कदर करते हैं और हम चाहते हैं कि वो हमारी कदर करें और कोशिश करें एक दूसरे, वो हमारे कानून जो बनाए हम उनको सराहें जहाँ तक मुमकिन है और वो हमारे फैसलों पर अमल करें, इतनी सी बात है।
1955 अब आई थिंक अब सेक्युलरिज्म में इंडिपेंडेंस की मूव ऑन आगे बढ़ेगा।
You see, as the Honorable Chief Justice said, there is one question. I had posed two questions. The stages, well, they are the stages of the same question. The first question was, you have to show that the Parliament is competent. This is a question of competence. But the probe doesn't end there. Even if the Parliament is competent, some provision of the law is in conflict with the Constitution, it can still be struck down.
So I stand corrected. Good question there.
You would not only have to answer the question of competence, you would also have to take us to each provision and justify that it is not in conflict with any provision of the Constitution. So keep that in mind and please proceed.
My Lord, with laws, I thought the Constitution is assumed, the party shows that this provision is unconstitutional, and then I defend that provision. It seems so that all of the provisions have so far.
You see, the burden is on the person challenging it, and the burden does not lie on you to justify it.
Yes, and then if the burden is
since the question has been posed, you can see.
And I'm assuming from this question, you can answer in my Lord's estimation that will.
I assume you're not going to rest your case by saying they failed to discharge the burden.
My Lords, now with this question, I actually wanted to move to 2055, but this question is something I'll come back to. I'll come back to it because
Go at your case according to your
if my Lords, I may take your Lordships to entry 55 now, and my reading of entry 55.
अच्छा पहले ये वजाहत कर दें, क्योंकि एक राय है कि 55 है, दूसरा है 58 है, दूसरा है तीसरी राय है कि 58 है, मगर 58 ना भी तो 55 फिर भी है। तो आपका क्या सेंस है?
मेरी राय में as far as section 5 is concerned, it is rooted in entry 55, and the other provisions are to be construed under Article 142A, read with 58, and then back to 191. So, as far as entry 55 is concerned, it may be read with entry 175 clause 2 and entry 175.
What was actually put by your predecessor in the line of arguments, Mr. Faisal Siddiqui, that it's a ping-pong effect. It goes from 58 to 191. Back to
58 is a gateway. I mean, it's 142, where everything starts, takes you to the list. 58 brings you back to the Constitution. 1 through 57 keeps you there. So that is how I see. I see how the Constitution is functioning. 2055, my lords. There was two parts, but I read these two parts somewhat differently than how my predecessor had read out. I I'll read it first, photo, and then I'll submit how I read it, and then make my submissions. Jurisdiction and powers of all courts, except the Supreme Court, with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution. I take a pause here. And the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers. My Lord, my reading of entry 55 is that the last two parts, the enlargement of the jurisdiction of the Supreme Court and the conferring thereon of supplemental powers, have to be read with the exception, except the Supreme Court. And insofar as jurisdiction and power of all courts are concerned, I read it, jurisdiction and power of all courts with respect to any that is in this list and to such extent as is expressly authorized by or under the Constitution. So this term, to such extent as is expressly authorized by or under the Constitution, is in relation to all courts except the Supreme Court.
So you're saying the enlargement of jurisdiction should not be read with expressly authorized by or under the Constitution?
Yes.
I didn't get this one. I didn't get this one.
What you're saying is, as far as the Supreme Court is concerned, the enlargement can only be done where there is specific authorization.
No,
You're saying otherwise.
I'm saying otherwise.
You're saying for the Supreme Court, you don't need any express authorization.
For the Supreme Court, there can only be enlargement, and we have to go to the language, and there is no such thing as far as
express authorization की जरूरत नहीं है.
So सुप्रीम कोर्ट के लिए ये अप्लाई नहीं करेगा, हाई कोर्ट्स के लिए करेगा. वो इसलिए करेगा because high courts में there are not just high courts, all courts, because there are three sorts of courts which are dealt with under the
No, but you are saying to read jurisdiction and powers of all courts to such extent as expressly authorized or under the Constitution. Yes, so you're saying read the jurisdiction and powers of all courts with expressly authorized by the Constitution.
let me just
Where is it expressly authorized by the Constitution?
I would read with respect to any of the matters in this list and this is in conjunction with, to such extent as is expressly authorized by or under the Constitution, and then the comma is separating what is to be done insofar as Supreme
So there's no restriction on enlargement of jurisdiction, as you read.
of the Supreme Court.
What happens to expressly authorized by?
This in my respectful submission, this is something which relates to the high courts, administrative courts, and federal Sharia courts.
So you mean the bar is lower for the Supreme Court?
And there is a reason. Because as far as jurisdiction and power of all courts are concerned, it can be done through statute, but only to such extent as is expressly authorized by or under the Constitution. And in relation to the matters in this case,
That can get, because that can be curtailed.
yes.
But in case of the Supreme Court,
It's can't be curtailed, and if I let me just walk you through Article 199 and then 212 and then 3.
Let me read this entry 55 just to make sure I am understood. I'm sorry, I'm still having some difficulty here. So as you read it, jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters listed in this court and to such extent as are expressly authorized by or under the Constitution.
So the and used after
The enlargement of the jurisdiction of the Supreme Court and the conferring thereon supplemental powers. That you say is separate from this.
so as Mr. Sattva just pointed out, you're saying that it actually turns on the word enlargement because there's a specific thing that the power could be given, that is enlargement. So we don't need to worry about any extent or anything because it's enlarging, it's not reducing, it's not altering, it's enlarging. So that's as simple as that. It doesn't have the
Your reading eliminates the word and surely
and from.
From the text.
So there are two ands here. One is after the list,
No, the first one.
the and, yes.
Jurisdiction and the first one is jurisdiction jurisdiction and powers of all courts
with respect to any of the matters in the list
any of the matters of the list
and
नहीं अगर आप आगे जो चीज आ रही पीछे से जोड़ रहे हैं तो ये एंड तो एलिमिनेट हो गया
and के साथ वो conjunctive हो रहा है ना
एंड नहीं
in conjunction हो रहा है ना and to such extent that is authorized by our constitution
and it makes it disjunctive and की जरूरत नहीं रहती ना
by right.
अगर आप इसना पढ़े jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list to such extent as is expressed by or under the Constitution. Is there any grammatical problem with this? Is there any grammatical problem? No. So therefore, on your reading, and is eliminated. And becomes redundant. And makes sense only if it creates the break and then relates such extent as expressly authorized by the Constitution to what is following. आप समझ रहे हैं ना?
What is following
अगर आप एंड की जरूरत नहीं रहती ना आपकी रीडिंग पे
तो एंड की जरूरत देखें अब यहाँ
दोबारा पढ़ता हूँ चलिए दोबारा
on that count my lord and जो है
दोबारा पढ़ते हैं ना
इसकी आपको कॉन्स्टिट्यूशन में भी लेके जाऊंगा कि मेक सेंस ऑफ इट
powers of all courts except the Supreme Court with respect to any of the matters listed in this list to such extent as is expressly authorized by or under the Constitution. Full stop. Is there any error, any grammatical error in this sentence?
No, it will be right.
So therefore, and becomes a
that is
right. मैंने full stop पे डाल दिया just to clarify the reason.
there is a reason. अब मैं इसको ऐड कर दिया इसको करेंगे समझेंगे इस तरह से कि there are two jurisdiction जो courts पे grant हो रही है. One is with respect to the matters in the list. We have to go to the Constitution, what the Constitution, the body of the Constitution is doing. And for that, if my lord may kindly turn to Article 212, for example. Let's go to 212, let's go to 199. Let's go to 199 first, and then see what is the authorization, the extent of authorization, as far as High Court is concerned.
उसमें तो जरूरत नहीं है
नहीं है जरूरत है
क्या जरूरत है
Clause 5 देखेंगे उसमें Clause 5 of Article 199, which says the extent to Article 199 applies. And there is carved.
Mr. Ranjan, I mean, before, are you looking at 55? I mean, we might lose ourselves in the grammar of it, but larger than that is perhaps the word enlargement.
Yes.
What is actually happening? You're enlarging the jurisdiction of the Supreme Court. It requires no extent because it is a positive thing. You're just adding to the Supreme Court's jurisdiction. So, वो उसके साथ पढ़ना, तो उसमें कोई
Respectful submission है कि नहीं पढ़ना होगा because वो counter intuitive है. वो इसलिए भी counter intuitive है कि there is nothing in 184, 185 में clause 2D है which says that through an act of parliament आप उसको ऊपर ले जाए उस amount को या review के अंदर
इसको आप इस तरह दोबारा
इसलिए there is nothing to provide का that extent क्या है, whereas in the case of high courts for example there is an extent which is provided. For the administrative tribunals also there is an extent which is provided.
Powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution. Full stop. आप इस तरह पढ़ रहे हैं उसको
जी हाँ
इसको surely on this grammatically speaking for myself there is an expectation कि इसके बाद भी कुछ आएगा अगर add हो ना उसके बाद एक expectation है and to such extent as is expressly authorized by or under the Constitution. Full stop creates a vacuum because there is an expectation to such extent as is expressly authorized by or under the Constitution. What?
Yes. So you
तो आपका and जो है
इसको एक सेकंड के लिए
समझने की कोशिश कर रहा
मैं आपको समझाने
and में ये प्रॉब्लम है अगर and इस तरह से रखते हैं ना and निकाल दे तो कोई प्रॉब्लम नहीं है
इसको जरा इस तरह से पढ़े and की निकालने की जरूरत and क्यों जरूरत है and को रखना. So let's just read it again. Jurisdiction and power of all courts with respect to any of the matters in this list. Let's take a pause here. All courts, matters in the list. And then, and to such extent as is expressly authorized by or under the Constitution. Full stop. So, the solution is that this language and the express authorization is necessary because 199 applies the constitutional jurisdiction of high courts in terms of territory, of course, but then there is a carve the persons to whom this jurisdiction can be applied. And then 212, Article 212.
Do we need a professor? Do we need to make amicus a professor of the English language, Mr. General?
My lord, I
think we can understand it whatever we understand it to mean. And can I just ask you a related question? Does the Supreme Court have power to enlarge its own jurisdiction? Yes or no? Here you are saying that Parliament, their side is Parliament can only do so through constitutional amendment. Now, I don't know why you are skirting the issue.
The resort is required to, is bound to act in accordance with the...
It cannot enlarge its jurisdiction, correct?
Yes.
How has the Supreme Court enlarged its jurisdiction in cases decided by 3-member benches, by adding on benches, and which jurisdiction was assumed then? There have been recent examples of the Supreme Court enlarging jurisdiction, but creating jurisdiction not envisaged in the Constitution. But those are sensitive matters, so you won't talk about them.
I want to talk something about it. I know, I want to talk something about it. Yeah. And let me just talk about it. And then
Why would you want to field another question? You can't field 5 questions simultaneously. You have to finish one.
I have to field this question and then I'll come back.
Why did the word expressly, अगर expressly नहीं भी होता, by और under का यानी इसका मतलब हुआ कि by के लिए भी express होना चाहिए. So by in itself is always express.
मेरा there are two. One is where the Constitution now, when the term by is used, the enactment in this case, the Constitution directly provides for what can and cannot be done. And under is where an additional act is required.
मैं आपसे एक सवाल इसे आगे ला रहा हूँ. मैं ये कह रहा हूँ चलिए. बाय का मतलब है कॉन्स्टिट्यूशन दे है और है कि उसमें आप देखिए अक्स करें अगर मिलता है. व्हाई डिड दे से एक्सप्रेसली मतलब कि बाय के लिए भी हमेशा एक्सप्रेस बाय itself is always expressed.
उसकी reason though, at least to my understanding, is because the Parliament has the power to determine jurisdiction and power of all courts other than the Supreme Court. So it was necessary that the Constitution states so. To what extent, with respect to what is already dealt with in the body of the Constitution, you can and cannot do. Because otherwise, when the Parliament legislates with respect to what courts, for example, Article 212 deals with administrative courts and tribunals. Under clause 1, sub-clause A, B, C state what can be done under these tribunals. And then clause 2 says no court shall otherwise grant injustice that and the other. So this is the clause, this is the extent of authorization under A, B, C. And this too then prevents Parliament from using its power under 1951 jurisdiction and power of all courts from conferring this power on the honorable.
You see, this is in the natural flow is to be read with the upper
Yes, that's my
So what is meant by the term enlargement? And if it was, is it just enlargement? Enlargement and conferment या creation of jurisdiction में फिर
सुप्रीम कोर्ट को लगता है एनलार्जमेंट वाला जो कोर्ट है वो लगता है
Learned Attorney General, what is the constitutional principle? If there can be two interpretations, which interpretation should be adopted?
One which favors the constitution of the study
Express authorization is required. The jurisdiction or power can be curtailed, but where it is enlarged, as my brother Justice Mansoor has stated, that should be welcomed by this court. It is being enlarged.
And my lord, in continuation of my previous submission, because there is no express authorization required, then what my lords now have to see is whether there is any prohibition in 184 or 185 from extending and enlarging 185 to apply to orders and judgments under 184. So if there is no prohibition, then you are not drawing that authorization from the language of